which is what would have happened in this case,
Yes.
Because there wasn't agreement, the court does not consider a hearing would be appropriate.
But has the court said that here?
Well, that's the power it would have been exercising because neither party agreed it.
Exactly, but that's what I'm asking. Has the court actually said it does not consider that a hearing would be appropriate?
Well, by implication, it said that. It hasn't expressly said that.
No. Well, why did you say by implication? I mean, it's routine for the High Court to say, we'll deal with something on the papers. But that doesn't mean to the exclusion of an oral hearing. It just means we'll deal with it on the papers first. And it may not be necessary to have a hearing. It's only if somebody's refused something. You might have got what you wanted.
Well, my lord, except Nolson, if one goes back to Nolson, the route by which, I mean, that would have been part of the analysis in Nolson, but Nolson doesn't say this was decided outside of 23.8. Nolson's analysis is the way in which it's dealt with on the papers is by 23.8c. 23.1.8, it's the same provision. So Nolson was not saying, effectively, because you have an automatic right of appeal, you don't need to rely, the court didn't need to rely on 23.8.1. It was expressly saying the court was relying on 23.8.1, but because of the practice direction, that then gave rise to a right to renewal. And so
it does matter that the practice direction no longer.
It does matter, and what's even clearer.
That seems to be the critical change.
But my lord, what's even clearer, and this is the critical change, which is new.
Yeah.
If you go to 23.8.3,
Yep.
if the court decides the application without a hearing under paragraph 1c,
Right.
and does so without giving the parties the opportunity to make representations,
Yep.
a party affected by the court's order may, within such period as the court may specify, apply to have the order set aside or varied or stayed.
Yes.
So the implication of that rule, certainly as we've read it, is that the default effectively is you don't have that right, but you do have that right if the parties weren't given the opportunity to make representations. What it also says...
You may be right. I don't see any of that in there, I'm afraid. It's all mystifying to me, I'm afraid.
In what sense, my lord?
Well, I don't understand what the problem is. These are very obscure, nuanced provisions. I don't at the moment. I don't see anything which tells me that the fundamental right to renew to an oral hearing, if you've been refused on the papers, which is set out in MD, has been abrogated.
Well, my lord, except if there's that fundamental right in MD, this rule becomes, in one sense, OTOs. What is it seeking to achieve?
Well, you may be right, but I would have thought that if the legislation is intended to take away such a basic feature of our system of justice, it would say so clearly. Now, in a sense, you're arguing. Usually, I would expect you to be arguing that you had the right, but you're saying that you didn't have the right.
Well, my lord, in one sense, the practical difficulty I've got representing my client today is that the most important thing from my client's point of view is to preserve the interim injunction pending the determination on permission, effectively. And so,
but if I have no jurisdiction to grant it, then the sooner I end it, the better.
Well, except, my lord, I'll come on to this, but of course, my lord has the power to sit as a High Court judge. My lord could consider it.
Well, that's I don't want to make you move around in your submissions, because
yes,
you must present your submissions in the order you think fit. But I'm not at the moment. I mean, you've shown me Section 9. On the face of it, I'm not sure Section 9 allows me to sit as a High Court judge today, because I haven't been requested to do so. There's no talk about there being a request from the appropriate authority. Do you want to go to that now?
Well, Marold, can I come back to that? Because I'm still focused in one sense on the courts, and as I say, I am very concerned, obviously, about preserving the client's position. My Lord has raised, in one sense, why am I taking this approach? The most fundamental point is the point I've just made about protecting the client's position.
Yes.
My Lord, I just want to test through that. My Lord is putting to me, as I understand it, and obviously this is an important issue of practice potentially for other applicants. My Lord is putting to me that, and obviously it's not just restricted to the admin court, but to use the admin court as an example, because this is a procedure that commonly happens, that where the applicant puts in, as the applicant did in this case, an application for interim relief on the papers, and the judge, having heard both parties, decides essentially
heard in the paper sense.
Sorry, yes, heard in the paper sense.
Yes.
And then issues an order, which is obviously something that happens very commonly in the administrative court.
Yes.
As I understand it, my Lord is saying effectively either 23.8c doesn't apply, or if it does apply, Rule 23.8.3 doesn't prevent a right of renewal.
Well, you may be right that it does take away such a fundamental right. Mr. Manknor may agree with you. I don't know. I mean, often the government does want to restrict rights, so he may say, fine, if you don't want to have a right of oral renewal, I'm quite happy to go along with that. I don't know. But on the face of it, I find it surprising that such obscure wording should take away a basic right, which MD Afghanistan confirms is the starting point.
Well, can I take you? I mean, my Lord, can I take you back to Nolson then, just to demonstrate why this is an important starting point? If you go back to Nolson at para 90,
page 90.
Page 90. Sorry, page 90.
Let me just get that. Yes.
You'll see there the bottom para, as my Lord's already seen, the citation of MD Afghanistan.
Yes.
Go then to the next page, para 50.
Yeah.
And what the Court of Appeal, this is why we started with 23.8c. Court of Appeal clearly wanted to consider the route by which this was achieved, because what had happened before.
Sorry, what was achieved?
The route by which the MD Afghanistan oral hearing could be achieved, because what had happened previously was, if you go to page 88, bottom of the last two lines going over to page 89, you'll see that the deputy judge who dealt with the case, the interim relief application, had concluded there was no jurisdiction, because what had happened was the applicant had relied on effectively the provision that allows for renewal of a permission application, and perhaps unsurprisingly, the judge had said, well, this isn't a permission application, it's interim relief.
Right.
So the court was concerned to see what route, if unsurprisingly, the Rule 54 didn't apply, what procedural route under the CPR allowed for renewal. And what the court sets out at para 15
Yes.
is the procedural route that allows for renewal. And the critical point is, and this is why I started with the provision I did, it started in the court's mind through Rule 23.8c,
Yes.
I think it's actually 8.1c,
Yes.
the provision that still applies, which is that the court is able to deal with a matter without a hearing if it does not consider a hearing would be appropriate.
Yeah, that's fine. That gives you the vires to deal with it.
Absolutely, my
on the papers.
Absolutely, my Lord.
What I'm not understanding at the moment, no doubt my fault.
No.
No, let me just finish. Right? What I'm not understanding is why simply taking a decision that you will consider something on the papers then bars you, if you're disappointed with the outcome on the papers, from having an oral hearing. In other words, having a second bite at the cherry.
But well, that's where, if one accepts the starting point I'm starting from, which is that what the judge in this case was doing, without necessarily expressly referring to it, was relying on the jurisdiction under 23.8.81c.
In our case or in Nelson?
In both cases.
Right. Okay.
Yeah. In both cases, he was relying on
it. But show me the rule which says that if that's what a judge has done, in other words, they have first decided something on the papers, that then prevents you from having an oral hearing.
Well, if you go back to 257, my lord,
yeah,
the problem that we have struggled with is if we're right, and we say Nelson says we are, that what the judge in this case did was determine the matter under 23.8.1c.
Yeah.
You then have 23.83,
yes,
sub-rule 3.
Yes.
If my lord is right that there is, because of MD Afghanistan, an automatic right to renew, the problem that then that then means that 23.83 is meaningless, basically, because 23.83 gives people who are in para 1c a right to renew in particular circumstances.
Where does it say right to renew? You may be right, but I'm just not seeing those words at the moment.
Well, it says you have the right to apply to set aside. Now, it's the right to apply to set aside that was if you go back to Nelson, rule para page 91.
Yeah.
The effect of the practice direction was, and you see this by the top hole punch. The effect of the practice direction was that it brought in CPR 3.3.
Yes.
And that gave the right to apply to set aside, vary or stay the order.
Sorry, where are you reading from?
Sorry, that's in CPR 3.3, quoted there in the middle of the page, and it's subparagraph 5, 3.3.
So let me just make a note of that. Hold on. Right. So that's the same provision you say as we now see in 23.
It gives you the same rights, effectively, the right to apply to set aside, stay.
Set aside. Variable state, yeah.
Yeah.
So, and where does this then go on to say that that's something you can't do?
Well, if you go back to 2.25.7, as things were in Nelson, because of the fact that 3.3 automatically applied, everyone had the right, if they'd been determined without a hearing under 23.8c, everyone had the right to apply to set aside, vary or stay an order. We now have a rule that still allows for an order to be set aside, stayed or varied, same language, but it only does so if the party was, if the parties were not given an opportunity to make representations.
Hang on, where do I see that language?
It's, if you go back to 257, subparagraph 3, before letter A, it's the second line of that.
I see. So
on the face of it, you've got now two categories of people who are potentially impacted by the application of 23.8.1c.
But when I find it very difficult to envisage a situation where a court would decide an application on the papers without giving the parties an opportunity to make representation.
Well, my lord,
that's just basically unfair.
Well, my lord may think that
At least one side has always had the opportunity to make representations.
Well, my lord, that may be what the concern is, because the reason I drew attention to the amendment rule, my lord, and just to put this in context, I don't know whether my lord has the amendment rules that I handed up this morning. Yes, these take effect. These have taken effect from the 6th of April, as you see from Rule 1.1.
Sorry, let me just get to that.
My lord, I've not handed you the amended rule. I've handed you the amendments, partly because there's an explanatory note that may be of some significance.
Sorry, I haven't got it yet.
Sorry, my lord.
Yeah, I've got it now.
Yeah.
Yeah.
If you look at, just to make it clear when these apply from, so they didn't apply at the relevant time, but they do apply now.
So it applies to me today?
Well, there's a transition provision which is unclear, but it would, I can't, given the jurisdiction must have been grounded effectively when we made the application. I wouldn't argue these apply to you today, but they may be relevant.
Well, I'm not sure you should make that concession, because here it is. Let's see what Mr. Macknell says about it.
Yeah.
But it may be that this provides the answer.
Well, it may provide the answer for another reason anyway. But my lord, if you go, Rule 1.1 makes it clear it applies from the 6th of April.
Yes. And today is the 10th of April.
10th of April. So the transition provisions, perhaps unsurprisingly because they're procedural rules, effectively...
Well, what the transitional provisions appear to say is that certain specified amendments only apply to proceedings ... on or after 6th of April 2025.
Yeah, but it's not, none of those rules that are subject to the transitional provisions are the relevant rule, because the relevant rule
exactly, that's my point.
Is Rule 6.
Exactly, that's my point.
Yes.
So it could be argued, but I don't know the answer to this, that Rule 6 has effect today because today is after the 6th of April. Now, what does Rule 6 say? Rule
6 changes the sort of the first part of paragraph 3, the introductory part, one might describe it as. Yes. So that the language now is what must have been denied is the opportunity to make representations about the substance of the application. So what it appears to be focused on is the situation where someone makes an ex parte paper application,
yes,
which in principle you can do,
yes,
and has a ruling on that. And in those circumstances, not surprisingly, because there's obviously unfairness to one party, you can have you have a right to renew. But the implication would be, as for the reasons we've already indicated, it's only in those circumstances. Now, the reason we provided, or one of the reasons why I provided the full document, is that if you go to the last page of it, you'll see this is the explanatory note from the Procedural Rules Committee.
Yes.
And it explains that the reason for the amendment is to remove a potential ambiguity. And I have to say, I've had helpful discussions with my learned friend about this, and one of the things that I think has puzzled both of us is whether the opportunity, whether in the rules that applied when this application was made, whether the rules that applied at that stage were focused on whether you had an opportunity to make representations about the procedure, or whether they were about whether you had an opportunity to make representations about the substance. And what appears to be the intention of the civil, what clearly is the intention of the civil procedure rules, is it's intended to make clear that the circumstances in which you have the right to apply for variation are when you've had an opportunity.
On your submission,
yes,
what is the position? Leaving aside any transitional problem, but if this case arose squarely after the 6th of April, on your submission, what is the legal position?
The legal position now, quite clearly, is because both parties had an opportunity to make submissions about the substance of the order.
Yes.
The only the only way of challenging that order, because it's a final order,
is to
go to the Court of Appeal.
Right. Okay. And you say that was also the position.
Absolutely, because
before. Right.
And partly because, as I say, this is not, on the face of it, the new rules are not intended to amend the effect. They're intended to clarify.
Yeah. Now, is this in dispute?
Thank you, my lord. Essentially, no. Well, can I make clear, though, what my lord said? The government may have a position. I don't have instructions on a government-wide position. Presumably the rules sit with the Ministry of Justice.
Yes.
Nor do I have general instructions. All I have are instructions in this case,
Yes.
which is that for the purposes of this application, we accept that analysis from Mr. Southey. Can I just a point that I haven't raised with my learned friend, because it occurred to me as he was making his submissions and looking at these provisions. The answer may perhaps be more straightforward, looking at page 257,
Yes.
Lord.
Yeah.
It may not hinge on whether the change has been made or not, so whether it's a right to make representations about the procedure or the substance. Because looking at this again, and assuming for the moment, my lord, that Mr. Southey is right, that the only circumstances in which a right of renewal occurs are those set out in the rules, that there isn't some extra power. For the purpose of this application, we accept that the rules appear to be comprehensive. And just while I'm on that, subparagraph 4 and 5 appear to support that, because that says, that provides for an application to be made for the matter to be considered at an oral hearing when it's been dealt with under paragraph 3. And as Mr. Southey says, it would be otiose to have that if there was already a power to seek to do that. But
Well,
leave that aside for the moment.
Well, I'm afraid this is what is worrying me,
Yes.
because it could be said that what 4 and 5 are making clear is that you don't have a right to renew at an oral hearing if your application has been certified to be totally without merit. That is dealing with that mischief,
Yes.
which I can well understand, and that's been in our civil procedure system for many years now. I have to say that if it's not in dispute, then fine. Although I'm not sure that jurisdiction can be conferred on a court by consent.
No,
But
it's not in dispute for the purposes of this claim, but it's potentially an important point, because this is part 23. It applies to all applications. It's not,
Right.
and
I'm also very concerned, I have to say, speaking for myself, I'm very concerned about the right to renew at an oral hearing in the High Court being removed apparently by a side wind, when I had always understood the position, and paragraphs 4 and 5 appear to confirm this, is that it's only removed where the court certifies that the application is totally without merit.
But what I see the force in that, from my client's perspective, it would have been preferable that the avenue after the decision on the papers was a renewed oral hearing before a High Court judge shortly afterwards.
Well, Mr. Blackwell, that's very, as always, you've been very fair and helpful to the court, so we can probably short-circuit this.
Can I just make the point that I was going to add, which may not be a good, but it seemed, looking at subparagraph 3, and the 3 conditions that follow. So if the court decides the matter without a hearing, does so without giving the parties the opportunity to make representations, whatever type of representations that is. A, party can apply to have it set aside within a period set by the court. B, if no period is specified, the application must be made within 7 days.
Yes.
And then there's an and.
Yes.
So it seems to me that the C that follows is also a condition.
Yes.
And the condition in C is that the order must contain a statement of the right to make such an application.
Yes.
The order, in this case, of the Deputy Judge didn't contain that provision. So it seems that the court doesn't need to decide whether it matters whether the rule change of the 6th of April happened or not.
No.
If this is a comprehensive code, then the answer is the order didn't provide for it under C, and therefore the only avenue was to the Court of Appeal.
I see.
So that may assist. In respect of
Yeah.
this hearing, my understanding is that the court would have jurisdiction to hear it, but in effect the rule in Nolson and MD is a rule of practice. The Court of Appeal won't hear appeals unless you've pursued your application. It's
not a jurisdictional.
It's not a jurisdictional issue because there has been an order of the High Court. But I'll let my learned friend.
I see.
Well,
Yes.
look, can I just come to two things in relation to that? One, I think, which isn't helping my argument, I have to accept, but I think it's probably, well, it is consistent with my duties to the court. One of the reasons why I haven't focused on paragraph 3c, the requirement the order must contain a statement of the right to make an application, is of course following Sonergy and the line of authorities that now follow that. The question always is, if there's a provision like that, what were the intended consequences? It sort of seems potentially unfair, it does seem unfair, if there would otherwise be a right to an oral hearing, for that to be deprived because of an oversight by the court. And so...
Well, I agree.
So I'm not sure that...
I have a lot of sympathy with that.
Yeah, but so, my lord, the second point, but just going to the point about jurisdiction, this is why I referred to MD Afghanistan earlier, and I haven't come to it. If you go to MD Afghanistan...
Where's that?
It's at relevant passages is at page 208. It starts at 208.
Yes, thank you.
You'll see at paragraph 12, the court starts by looking at section 16 of the Senior Courts Act.
Yes.
And that's, obviously I provided that to the court as well. It hasn't changed as far as I can see.
Yeah.
It provides the court has a jurisdiction to hear and determine appeals from any judgment or order of the High Court.
Yeah, let me just got that here somewhere. Yep.
It's at the end of the paragraph. There are exceptions to it, but none of them seem relevant on the facts. You then see at paragraph 16, the court and this is the context in which the key paragraph, paragraph 21, it should be viewed. Right. The court accepting, although recognising it hadn't had full argument on the matter, that in principle, section 16 would appear to give a right of appeal.
Yes.
But the question is not whether it had jurisdiction, whether it should exercise its jurisdiction.
Yes.
And well, that's why, in one sense, our first fallback position before having to rely on section 9 is if we've adopted the wrong procedure, then the reasons for adopting the wrong procedure are totally understandable. In those circumstances, assuming the court thinks there's merit in this, what the court would have jurisdiction to do is to say, would rather not consider this because of the fact it's important that there is a right to an oral hearing. It should be determined by the High Court first, but because we have jurisdiction, we can maintain the order, the interim order until the High Court considers it. That would be one way of dealing with the matter, my lord, because it's not a question of jurisdiction. It's a question of whether that jurisdiction should be exercised.
Well, that appears to be common ground.
Yes.
Yeah, and that's a relief to me, I have to say, because the parties cannot confer jurisdiction
Yes.
on a court by consent.
Yes.
But since it appears that I do have jurisdiction, then the question becomes one of discretion.
Yes. Albeit, I accept also what my learned friend says, which is this is an important issue of practice. I mean, as I say, I think I'm particularly alert to this issue, having been through MD and having been through Nolson, and was somewhat surprised by the rules. But the rules on the face of it cause a problem because they limit the circumstances. What Nolson said. I mean, in summary,
we don't need to go back. Yeah, you've rehearsed all of that.
Yes.
I'm conscious of time constraints.
Certainly.
So this is probably the way through the procedural thicket.
Yes.
Do you want to say anything about the alternative route of Section 9?
Well, my lord, if there's, I mean, Section 9 was our ultimate fallback. it reflect the reason I drew attention to it was I was trying to provide. My lord will be familiar. I certainly have appeared in a couple of cases where, for example, the Court of Appeal Criminal Division has reconvened itself
Yes.
immediately as a divisional court,
Yes.
where it decided the wrong procedure had been
Yes.
adopted.
Can you just help me with one
Yeah.
curiosity about the wording of Section 9?
Yeah.
Because it may be important. If I say anything about it at all, it's as well to be. What's the phrase you rely on in Section 9, which allows me to sit today as a judge of the High Court?
What I rely on is essentially the fact that you have jurisdiction of the High Court. I mean, it's obviously the table that indicates as a judge of the Court of Appeal, you are competent to sit in the High Court.
Well, it says on request, and subsection 1 says at the request of the appropriate authority. And then, then it gets all very complicated, as is the norm these days with legislation, with lots of new subsections with capital letters inserted. And I got rather lost in this. So what do you rely on? Which says that I have been, looks as if consent has to be given by the Lord Chief Justice, now the Lady Chief Justice, and they can only give consent with the agreement of the Lord Chancellor. Have I got all that wrong?
Well, on the face of it, I'd say that would appear to be correct. The problem I've got was my lord, as I say, will be aware of the practice I've described.
Yes.
I can't see any other. I was looking at it yesterday when my lord sort of raised this, and I was thinking further about it. I was looking for a statutory basis for that practice.
Yes.
That's the best I can find, my lord, and it comes down to that. I have to be honest.
All right. So there's nothing particular in the wording of Section 9 that you want to draw to my attention?
No, it's simply the fact
I
that
certainly agree with you that as a matter of practice, judges do frequently reconstitute themselves as judges of the High Court.
But I've struggled to find in circumstances where obviously the jurisdiction of both the High Court and the Court of Appeal is governed by statute, this statute, I've struggled to find the statutory authority for that.
There may be some small print somewhere. When I was appointed to the Court of Appeal, there may be some small print somewhere.
Yes.
Which is on the internet somewhere, which said that I've also been requested from time to time to sit as a judge of the High Court.
Well, my lord, that may be. I mean, I sort of struggled. I struggle for two reasons. One, I'm always conscious of the fact that as a lawyer, the most dangerous thing is what you don't know in one sense, because you don't know what you don't know.
It can be a real problem, I know in practice, because occasionally members of the Court of Appeal are asked to try criminal cases in the Crown Court, which I notice is dealt with in the same table, the same column of the same table, as says that we're judges of the High Court.
Yeah.
And we are not all judges of the Crown Court, and that can be quite difficult in practice, because I'm aware that a number of my colleagues have had to be given specific authorization to go down to Southwark Crown Court, for example, to try a particular case.
Yeah.
The rest of us can't just rock up and say, well, we're judges of the Crown Court.
Well, my lord, the other thing that sort of surprised me, but I can't find a provision, there may be one that I've overlooked, is that my lord will be very aware, having sat in the Crown Court, that there are specific provisions which say that a judge of the Crown Court can sit as a magistrate, and it's very clear about that jurisdiction.
Exactly.
And I haven't been able to find anything equivalent to that.
No. Anyway, it sounds as if we're not going to have to go into that additional thicket.
I don't think so.
Because your primary route through appears to work, and Mr. Manknell doesn't dispute it, at least for the purpose of this case.
Yes. I mean, the only thing I would just sort of, before moving on, would add is that, as I say, as someone who was particularly alert to this issue, the changes to the rules came as a surprise to me. And I think there may be value in clarity as to what the rule means, but whether this is the right case to resolve that, I don't know. Given obviously,
I'd rather doubt it.
Yes.
But anyway, so that's jurisdiction. Now, turning to your application, what you're asking, is this right? You're asking for permission to appeal against the refusal of interim relief by the High Court.
Exactly, my lord.
Right. And why should you have that permission?
Well, my lord,
Given that it was an exercise of discretion by the High Court.
well, there's a couple of things I would say first about that. Firstly, in relation to that, there is an issue, and we've again highlighted that in our skeleton argument, about what test my lord should apply in this context. We recognise, obviously, that case law indicates, and we don't seem to suggest this is wrong, that it makes it clear that what's an issue here is an appeal. But obviously, it's an appeal in circumstances where what happened procedurally was that there was a pretty summary procedure, didn't involve an oral hearing, and in particular, on the face of it, didn't take account of the reply that had been filed by the applicant, because under the order there was no provision for that, but a reply was filed. There's nothing in the judge's order that indicates any account was taken of that. And also, on the face of it, the judge didn't engage with half of the underlying grounds, which are the grounds in relation to the time that was being taken to decide the new licence application. Now, all of that, our fundamental point, and I can go to the underlying material in relation to this, is that this court's approach is this court is required to decide whether the judge was, I use the language of the CPR, but it's a language that's been sort of picked up by the Supreme Court in particular. The issue is whether the judge was wrong, to use that language. The Supreme Court makes it clear that wrong is not the same as a significant error of principle. It is a wider concept. That was made clear in I think it's in the Supreme Court. Can I give you the reference, my lord?
Yes. Well, shall we go to that?
Yes, I think it's worth going to.
Yeah.
It's Authorities, page 174.
Yes.
Now, I'd said, and I'm going to come onto this, this was a case specifically considering proportionality.
Yes.
But it's, in my submission, not restricted to that. Para 64 is the key paragraph,
Yes.
which indicates the issue isn't whether or not there's a significant error of principle, it's about the cogency of the conclusion. Now, as I say, that was concerned with procedure, with proportionality. That was the direct issue in R. But if you go back to para 60, you'll see that one of the authorities that was relied on for this approach was a case called Abdallah versus Badarani, which was a concern about, was an issue about whether there was a good reason for deciding to treat something as a valid service, which also used the language of wrong, reflecting, as I say, the CPR itself. What it makes 2 points. Firstly, it indicates that what was an issue in that case was not an issue of discretion, but the evaluation, the value judgment based on evaluation of a number of factors. Now, if one thinks about the circumstances of this case, my lord,
Yes.
the first thing that the judge, and the second thing that the judge engaged with, although ultimately I accept that interim relief is discretionary, the first question that the judge had to decide was effectively the strength of the underlying judicial review claim. That is, we would submit, properly regarded as a value judgment. Secondly, he had to look at balance of convenience. Arguably, also we would say a value judgment.
Yes, but are you going to? Sorry, forgive me for interrupting you, Mr. Dudley. At some point, are you going to help me with why the approach we took in the Rwanda case isn't the one that I should take today? Don't go out of turn.
I hadn't planned to.
I mean, you referred to it in your skeleton argument.
Yes.
And you've sidelined very helpfully the relevant passages in my judgment. It's tab 2.
Yeah.
Don't go to it, as I say, out of turn. But I mean, we dealt with all of this. We have something about the appeals against grant refusal of interim injunctions at paragraph 80. And we cited the well-known textbook by Sir David Bean and Andrew Burns. We cited the judgment of Lord Justice Lewison in Frank Industries.
You did, my lord. The point that we've made in our skeleton argument, and I'll take this on now, is, and this is one of the reasons for going to the passage I did, and it was the second thing I was going to draw attention to, is that if the second sentence, the third sentence cited in Abella, is quite important in my submission, because it talks about how the readiness of the court to intervene will depend upon all the circumstances of the case.
Well, fine, but do you accept that the approach which this court set out in the Rwanda case at paragraphs 80 to 84 is the approach which this court should take on attempted appeals against the refusal of interim relief?
We accept that it applies, yes. The reason I'm slightly hesitating, my lord, just making sure I've got the right passage up, because the reason I'm slightly hesitating, my lord, is that ultimately, when applying those principles, what the court the reason I was focusing on R is that in the judgment, a lord at the court cites, consistent with what I've just been saying, as I say, Sir David Bean and Andrew Burns, and at para 82, and makes the point, and we'd also drawn attention, it's in the bundle of authorities, to Frank Industries, that the issue is whether whether the lower court was wrong. Don't dispute that. The point I'm trying to make, my lord, perhaps inelegantly, is that when looking at wrong, and that's why I drew attention to Adela as cited in R. Two things I'm trying to make. The point I'm trying to make. One is wrong on its face isn't necessarily as restricted as perhaps sometimes it's suggested to be. It's not necessarily just about an error of principle, but two, it's appropriate to take account of all the circumstances. And so part of the circumstance, and this is really where I was focusing. It's not, and perhaps should have started slightly differently. When looking at the circumstances include the procedural context in which the order had been made. Had this been a fully argued oral hearing, the approach in DB, which we also draw attention to, would be much more obviously able to apply, because the first instance judge would have had full argument. The counsel would have been expected to not use it as a tryout on the road, to use the phrase that sometimes is used. The counsel would have been expected to deploy all arguments. The judge would have had the benefit of considering those arguments fresh, and as a result, his judgment would inevitably, or her judgment would inevitably have had to be given weight. We're in a slightly different circumstance because of the procedure that occurred at first instance. And so what I'm saying is that wrong is not disagreeing with what my Lord's said there, and I'm not disagreeing with the book, but what I'm recognising, or what I'm trying to argue, is that wrong is a flexible concept. It can take account of the circumstances in which the order was made, and the circumstances in which this order were made were such that the benefits of an oral hearing weren't enjoyed by either of the parties, and those benefits are important.
Right.
But my Lord, that's why, to be clear, we've not in our grounds just said retake, and we hadn't in our skeleton said just retake this decision. We are saying that we have to identify, but we've tried to identify reasons why we say that the matter was flawed.
Yeah. Why don't we move on to those? You know?
Yes.
Why is the judge's decision wrong?
Well, the first reason we say, the first reason why we say the judge's decision is wrong is the fact that there was no consideration of the delay issues raised in the underlying judicial review at all. And those issues do overlap, because clearly if we were right that in fact the underlying sponsor application should have been decided earlier than it is being, that would have potentially resulted in the grant of a further sponsor license. It would potentially have resolved all of these problems, because the applicant would have been able to obtain the certificates of sponsorship.
Right. Okay. Well, I don't want to impose a guillotine at all.
No.
But you have now had approximately an hour, or even an hour and 10 minutes. So how much longer will you be?
I'm aiming to finish in 15 minutes.
Okay.
I apologise. It's just
There's
jurisdiction.
there's no need for apologies, but I will hold you to 15 minutes. All right. No.
So, my Lord, there is the issue of delay.
Yes.
And
yeah, I've got that.
And the delay issue we submit is a strongly arguable ground of judicial review.
Well, that's your first point.
The first point. Well, my Lord, I don't know whether my Lord would be assisted by us saying more about the arguments about delay.
But Mr. Southey, it's a matter for you how you present your case.
Well, my Lord,
you've got 15 minutes.
Yes. My Lord, what we say in relation to delay is that the Home Office's material, in summary, demonstrates that it can, normally will, take decisions in this context far quicker than the 6 months it has so far taken. The explanations given for the delay in this case are given in the skeleton argument, but they're twofold, effectively. One is that there was the appeal pending, and that the Secretary of State had decided to wait for the appeal. Now, that, we would submit, is on the face of it ex post facto reasoning. Appointments were arranged for inspection visits. They were cancelled. It was only in the email of the 7th of March that the issue of the appeal was raised. And if you look at that email very quickly, it's in the supplementary bundle, page 235. Remember, this isn't about in relation to an appointment that was arranged while the appeal was pending. What seems to have prompted the cancellation of the visit was the handing down of the judgment. It's the middle sentence. what the grounds, for example, point to is that that is the first time that the fact the appeal is pending is raised. Previous visit, which was set for December, was cancelled essentially because it was said the company wasn't yet to be visited. It's also unclear what the relevance of the appeal is, in the sense. Certainly that wasn't something the appellant had been told about, but it's unclear what the relevance of the appeal is, in the sense that if the appeal failed, we'd be in the situation where we are now in, where the licence is required. If the appeal succeeded, one would assume there was likely to be a desire to understand what the current situation of the company was. And in any event, if the visit was success, it would potentially bring to an end the need for any litigation. The other point made is that the application was obviously complex. But from the 10th of December, because that's when the first visit was arranged, that was a visit arranged for the 17th of December, it's been clear that what was known to be necessary was that the next stage was an inspection. And prima facie, they can be arranged very quickly. On the 10th of December, arrangements were made for an inspection on the 17th of December. And all of that needs to be considered, as I say, in context of several things that we submit potentially make the delay unreasonable. Firstly, the clear statements that decisions can and will generally be taken very quickly. We've referred to the material about that in the time I'm not going to take you to it. Secondly, the fact that it was clear that a number of people, a number of individuals' futures really, to some extent, depended on this. Not just the appellant, it was their staff and their residents were potentially going to be impacted by whether or not a licence should be granted. And there's simply no explanation put forward for why the delay has taken so long in this case.
Yep, right, that's delayed.
So that's the first, and that's just not, and as I say, that is relevant to interim relief, because it's, if the matter had been determined quickly, then the status of the employees could be potentially resolved. Secondly, there's no consideration of the appellant's response. That is filed at page 43.
You made that point.
Yes, I have. But that goes to a number of the matters that were relied on by the judge. In terms of the judge's assessment of the merits,
yes.
We make a number of points about why it was flawed. Perhaps the most significant was that he directed himself that the wider impact issues were directed by the Court of Appeal in the previous appeal. And the impact was considered in the context of revocation, and the court reached its conclusions that it reached about revocation. However, it's quite clear in our submission that, and the court referred to this in its judgment, that a distinction was being drawn in that case between impact being relevant to revocation and impact being relevant to steps that might be taken to mitigate the harm of revocation. And we've, in our grounds, drawn attention to, in the judicial review grounds, the evidence which my Lord may remember, which was from the decision maker, who said we will look at, for example, staying, enabling staff to remain for slightly longer to avoid the impact of sudden loss of staff and the impact that may have on care. Paraphrasing the material, my Lord, I can take you to the position in the grounds where we cite that, but my Lord may remember that.
I do.
Yeah. And so the Court of Appeal was dealing with a different issue. This was an area where the Home Office's own evidence suggested it accepted impact was potentially relevant, which is how you deal with existing staff and potential consequences of loss of staff.
Right.
Linked to that, my Lord obviously will be aware as well that we made an application. We sought to argue that the final order of the Court of Appeal should continue the existing arrangement in relation to immigration for a short period of time.
Yes.
we drew attention in our submissions in support of that to the potential for this sort of challenge. And the court expressly noted that in its order as one of the factors that was relevant to refusing to extend the order. So the judge is wrong in our submission to say all of this was addressed by the Court of Appeal. It wasn't in our submission. The issues are different. We're talking now about a short extension to enable, firstly, orderly arrangements to be made for the staff who need to depart, but secondly, to enable two things to happen. One, the judicial review to be determined, the third judicial review potentially to be determined, but probably more realistic. Sorry?
Fourth or third?
Sorry? The third.
Okay, right.
But secondly, probably more realistically, because it's likely to come first in time now, looking at the situation we're now in, to allow the application for a sponsor licence to be determined. And there is a real issue here about rationality in our submission there, which is if the sponsor licence is going to be determined in the near future, there has to be a prospect, it may be difficult, but probably impossible for the court to assess how likely this is, but there has to be a prospect that, in fact, the sponsor licence will be granted. That will allow the existing workers to continue in post. And we're talking about, as a result, a short period until that's resolved. And my lord, that is, in one sense, at the heart of the rationality ground. And that simply wasn't something before the Court of Appeal. And so the judge is wrong to
Yes.
focus on that. My lord, the judge did deal with balance of convenience
Yes.
as well.
Yes.
In relation to
in the alternative.
In the alternative, I accept that. In relation to that, the first error that we've indicated is that he focused on the fact that and some of these were points that were addressed in the reply, I should make clear. He focused on the fact that the decision of the Secretary of State on the 7th of November was clear. It was clear, but we obviously made clear that we didn't accept the final point, which was that there would be no variation of this 14-day time limit in relation to it. We made the point, the appellant made the point that it would be impossible in these circumstances to foreshadow all the circumstances that might arise when we reach the point where the appeal was determined. It's difficult to see in November what else could have been done, because of course that agreement was reached in the context of an application for interim relief. Pretty unattractive. It's difficult to see how we could have gone to the Court of Appeal and to say, well, we've got the interim relief now that we seek. What we're looking for, though, is for an order extending the period at the end of it. That doesn't seem to us, certainly didn't seem to us, to be something that would be realistic to raise. So it's difficult to see what else the applicant could have done to challenge the 14 days. So in terms of balance of convenience, that it doesn't seem to be of any great relevance. In terms of the 2 years to adjust, that was something expressly dealt with in the reply. And the problem with that in our submission is that what was the company and its employees intended to do? The only thing they could have done would be effectively to replace the existing workers, but that was what was being litigated. It's difficult to see what else could happen. And as the reply pointed out, that although staff numbers had reduced, what one was talking about was a sudden loss of staff.
Is the net effect of all of this that although the challenge to the revocation
Yes.
of the sponsor license in JR1 has failed,
Yes.
including on an appeal?
Yes.
And although it was envisaged, certainly by the Secretary of State, that there would be a short period of time so that there could be some mitigation on employees,
Yes.
that actually it's not going to be short at all. It's going to be months and possibly years.
No, my lord.
Why not?
Because the For two reasons. One, well, three reasons actually. The first, but probably most important one, is, and this hasn't been challenged by the Secretary of State, and this is where the fresh evidence is potentially relevant. The decision on the fresh sponsor licence is now likely to be reached within 2 to 4 weeks. If that's positive, then that will allow certificates of sponsorship to be issued for the staff. And that is likely to resolve issues.
Sorry, new licence is likely to be what period?
2 to 4 weeks.
2 to 4 weeks from today.
From today. Well, from the inspection, I think, which was a few days earlier, but effectively, I don't think it makes any huge difference.
What was the date of the inspection?
It was
2nd of April.
2nd of April.
Thank you. Right.
And my lord, that's consistent with the timescales in the materials we've identified, which obviously recognise this is an area where decisions are taken pretty promptly, basically.
Right.
Secondly, my lord, it will. I mean, perhaps in one sense, one way of looking at this is what's the worst case scenario. Worst case scenario is that the application is again refused soon. In those circumstances, the applicant will potentially have two choices. The appellant will have two choices. One, will have to decide whether or not that is a challengeable decision. But secondly, in those circumstances, it will obviously need to make arrangements. And what was part of one of the things we were pointing to was the fact that and this is why where the policy about revocation of licences potentially comes into play. The revocation of licences policy in our submission indicates that it's unsurprisingly acknowledged that making arrangements for orderly departures of staff, because of course the staff have to immediately leave the country. They don't any longer have leave. They can't carry on working. Takes time. The period in the policy is 60 days.
Yeah, we know all of that, and the point the judge was making was that everyone's had 2 years to be thinking about these sorts of things. And I think what you're envisaging is probably going to take years.
I'm not. What I'm envisaging is the licence application being resolved. If it's positive, that's an end of the matter. It potentially allows all the staff to work.
Yes.
If it's negative,
Yes.
then what we're looking for effectively is a shortish period, and I refer to the 60 days.
60 days.
Yeah.
That's what you're looking for. Well,
Yeah.
from today?
Sorry?
60 days from today.
Well, in one sense, no, because it's from the decision. Because one of the reason why we challenge the judge's approach to 2 years is what are staff meant to do, what's the company meant to do in circumstances where it has a valid application pending. Because all that it can do is that either those staff continue to work or they don't continue.
What they're expected to do is when there's been a revocation, everyone complies with the law.
Well,
And they, as a matter of grace, have been willing to contemplate some short extensions beyond that. But you don't have a legal right to any of that.
well, my lord, you would have under the policy 60 days from the revocation
Right.
to make an orderly arrangement. That's why I picked up on the 60 days. It's the point I'm making is that, and this is the point we made in our reply, which doesn't seem to have got through to the judge, is that if one considers the situation while the judicial review was pending, while that was pending, while the appeal was pending, there was obviously some prospect of success.
Yes.
Because
but also people should have been thinking about that they might not succeed.
Well, but what will people, in terms of preparation, what was the company?
Well, that's what I'm afraid, Mr. Southey, and I don't want to keep going around the houses because you're already over your 15 minutes.
Sorry.
That is what leads me to suggest that what you're contemplating in practice is not a matter of days or weeks, but months and years.
Well, my lord, no.
Because actually what you're saying is that you were entitled to wait till the outcome of the appeal and then take stock of how much time are we going to need now to sort things out.
My Lord,
That can't be done within 14 days, or...
My Lord, I'm not saying that, because, and it's one of the reasons why, the other reason why the affidavit is, or sorry, not the affidavit, witness statement is of some relevance, because it's not that nothing is being done, in the sense that the company has run down its overseas workforce, it has gradually adopted, it has sought to recruit, it hasn't had any alternative, it's had to recruit internally. But what I'm talking about is at an individual level, the staff who've decided to remain,
Yes.
they still, in one sense, have to be, well, in a very real sense, the company couldn't have sacked them saying, well, we might lose this appeal, so we need to replace you with a British worker.
Yes.
And they, as individuals, are entitled to say, well, we still have time. We must have a reasonable opportunity to then rearrange.
And how long is a reasonable opportunity?
Well, that's why I
And
picked up the 60 days, because the 60 days is...
Oh, okay, I understand. As I say, it is 12 o'clock, Mr. Savage.
Sorry, my Lord.
No, there's no need to apologise. I really do have to give the other side an opportunity. This was listed for half a day, including potentially a judgment. Is there anything else that you need to say?
Can I just in this, in terms of the balance of convenience, in one sense, the critical issue here, and we did in our submission plead it as, and the judge certainly doesnment suggest he thought it was going to be years. We did plead it as a short period because.
No, I've got that.
But Lord,
60 days is what you said, right?
All I would say is that has to be balanced against the potential impact of a sudden loss of staff, and the evidence was clear, and that's not what the judge did.
No, I understand that. Yeah. No. Is there anything else that you need to say?
Well, I think that covers everything.
Of course, I've taken into account what you've said in your written argument very fully. I don't want anyone to feel that they haven't had a fair opportunity to make their submissions.
No, I'm content, Lord. I just wanted to finish off that one point about that, and in one sense, just that fundamental point, which is the judge in terms of balancing hasn't said. It's the other side.
Thank
you. Thank you, my Lord. My Lord may remember the details of the substantive appeal, but can I just remind the Lord of the essential detail, which is that the revocation of this sponsor licence was in February 2023. There then followed a series of applications for interim relief. First, while the High Court went through the process of considering permission, and then it took quite a long time for the substantive hearing to be heard, and then there was a further delay before judgment was handed down. There were then further periods because of the appeal to this court, and my Lord may remember that for the final period there was an agreement in place. So there had been a further application for interim relief made to this court towards the end of last year, before the appeal, which was dealt with by consent, following an agreement from the Secretary of State that interim relief would be granted until the appeal was decided, in fact until 14 days after that appeal. And that meant that the outstanding applications for leave to remain would not be determined during that period. Well, once the decision in the appeal was handed down on the 11th of March, 30 days ago, the appellant made an application to this court for interim relief. I've set out the key paragraph in my skeleton, but for your reference, in the supplemental bundle, it's at pages 249 to 250, and that's the order of my Lord and Lord Justice Baker, Lord Justice Jeremy Baker, refusing the application for interim relief that was made after the handing down of the appeal. And you'll have seen that it says that paragraph 3, the Court of Appeal is not persuaded, first, that it has the power to grant the injunction, or, if it does have the power, that it would be appropriate. The period of 14 days provided under the agreement allows the appellant's employees the opportunity to apply for leave to remain, and then in the event that the appellant pursues an application for admission to the Supreme Court, allows the opportunity for an interim order from that court, and alternatively, in the event that they continue to refuse a request for a short extension, the respondent does, the appellant has other remedies outlined, which were in effect going back to the High Court and so on. But certainly the view of the Court of Appeal appears to have been that it's not appropriate, and the period of 14 days did permit the employees the opportunity to apply for leave to remain. My Lord, the effect of my Lord's order following this application for permission to appeal in effect extended the interim relief yet further. It has now been 30 days since the 11th of March.
Yes, because it was made as an urgent application, which I would have had to deal with on the papers on the afternoon when it was put before me. And I took the view that I was not prepared to grant that relief without considering anything the Home Office would wish to say.
Entirely understandably.
And I also took the view that I needed an oral hearing, which I have to say today has demonstrated was the right thing to do, in my view, because you've got important things that you need to say. Now inevitably, I'm afraid, Mr. Magnol, that sometimes has the consequence of causing further delay. But you'll understand why a court does that. It's because I can't preempt what the outcome is going to be. Even now, I have no concluded view on what the outcome is going to be. I've got to consider what is said today.
Lord, no criticism at all was intended or implied. The reason I mention that point is that it indicates that the appellant has had a further period to put its affairs in order. It's not simply the 14 days that was agreed. The result of my Lord's order is they have, in fact, until today, had 30 days. The reference has been made to the policy. You'll have seen in our skeleton argument, you have it in the bundle, but the relevant sections in the skeleton argument, paragraph 25. Yeah. It's not right for Mr. Sully to describe that as being 60 days. The policy does not provide 60 days. The policy provides that from the date of revocation, which of course in this case was in February 2023, we will normally cancel, brackets shorten, employees' permission, so they have only 60 calendar days left. We will not normally cancel the workers' permission if at the time we consider cancellation action they have no more than 60 calendar days permission remaining. So what the policy does is, as of the date of revocation, so in this case back 2 years ago, you would have up to 60 days. So if you had 60 days or more of leave remaining at that particular time, you would keep those 60 days. If you had 30 days, you would keep your 30 days. That's what the policy says. So, well, then dealing with the position.
But anyway, is this right, Mr. Magnol, that that's one of the grounds of challenge in the underlying application for permission in the JR4?
So one of the grounds is that they say, well, we accept we don't come within the policy, but we come within the spirit of the policy. Yes. Well, you may or may not have seen our summary grounds of defence where we deal with this.
I've glanced at them. I've seen that they've arrived.
Yes. Yeah, I mean, they weren't before the judge, of course. No. But our position is it's absolutely right for them to say it's not within the policy. It's not. But you can't take from this policy that there's a spirit that you get 60 days. Yes,
but the more fundamental point may be that the High Court has not yet determined that application for permission.
No.
So that can cut both ways. I mean, that could be a good reason for granting interim relief, so that the merits of the application for permission can be adjudicated upon. Or it could be saying, well, at the moment, I'm not in a position to say whether that's a good arguable point or not. Because I haven't seen, for example, the defendant's response. But what do you say follows from the fact that permission hasn't even yet been determined?
So in this case, we say that supports the Secretary of State's position, because the judge in this case, without seeing the benefit of summary grounds of defence or any substantive response from the defendant, was able to conclude not only that the balance of convenience favoured the Secretary of State, but also that there was no real prospect of success. So the position has only improved from the Secretary of State's perspective with the ability to put in a full response. And this court is not deciding the application for interim relief, it's deciding whether the judge was arguably wrong, with due deference to the fact that it's a discretionary decisions and so on.
Indeed.
And so the fact that the judge was able to, and he deals with all of the relevant, I'll come back to the point about delay, which he doesn't address in terms, but he deals with all of the other matters. So he doesn't say he doesn't deal with these points, he does. And we say that is, I mean, it's a perfectly detailed decision on interim relief, as you would expect on the papers. And so our overall submission is first that the judge was right for the reasons that he gave. Secondly, we do say that if he made any error, for example, in respect of the issue of delay, if my lord found it was an arguable error not to specifically address that ground of challenge, then this court would also need to look at whether in fact that makes any difference. We say in this case the outcome is sufficiently clear that permission shouldn't be granted anyway. Can I, would it help if I just...
Does that come in at the balance of convenience stage or earlier?
At both stages. Well, to keep this as short as possible, in respect of the law, I can't do better than this court's summary in the Rwanda case, paragraph 74 to 84. I just highlight 2 points that we've mentioned in the skeleton argument. The first is the point taken from X and approved in Rwanda, or reiterated, that there needs to be a strong prima facie case. The Lord Justice Lindblom in that case said that that's not a threshold. So my understanding of that is that it's not a modification of the real prospect of success, but it comes in at the balance of convenience stage. So at the second stage, the court needs to consider, is there not only a realistic prospect of success, but is there in fact a strong prima facie case?
Yes.
But whichever way, we say that it doesn't meet either threshold.
Yeah. Certainly my understanding, but I'll be corrected if I'm wrong, has been that this is not only to do with interim relief applications, but generally when this court is dealing with attempts to appeal the exercise of a discretion in the High Court, generally speaking, we ask ourselves, has the first instance court erred in its approach? And even if it hasn't, whether it's come to a conclusion which was not reasonably available to it. There's a real danger of reinventing the wheel here. We deal with this every day, with lots and lots of interim decisions, which are discretionary decisions. But Mr. Southey says, well, the R case governs, and that doesn't require an error of principle.
I don't think so. I mean, looking at, I mean, R is not a case about interim relief at all. R is a straightforward appeal on the merits, looking at the type of error that's required to found an appeal. The approach to the specific question of the review of a discretionary decision by a judge to refuse interim relief is set out in my submission comprehensively in paragraph 74 to 84, I think it is, of Rwanda.
Yeah, but where I would stress, I wasn't trying to reinvent the wheel. I mean, all I was doing there was summarising what I take to be well-established principles, including citing some decisions of this court, like the Frank Industries case.
Yes, but the difference, and the point that I make about X, is that the strong prima facie case,
yes,
which I think comes in at the second stage, is specific to public law cases. And so it is an additional hurdle for the appellant in this case. And the other point is that the point, I think this court took it from Sir Clive Lewis's book, but it's also in the detention action case that you have, that the public interest is something that the court needs to take into account at both stages.
Thank you.
So if I can then turn to the merits. So in terms of the challenges in respect of the period of time that the Secretary of State has given. So there are four grounds altogether. There are 2 grounds about this and 2 grounds about delay. The point about the The first set of those two is covered in our skeleton at 25 through to 28. And the appellant argues first that the policy, even though it doesn't cover this, should be seen as covering it because it's within the spirit of the policy, or secondly, that it's irrational for the Secretary of State not to have done so. In terms of the policy, I don't think I can do better than repeat what I've set out in the skeleton argument. I've explained what the policy does, which is to give up to 60 days from the date of revocation. As to rationality, we would make these additional points. Firstly, that it's perfectly rational that in this sort of case, in this case in particular, that a sponsor who has lost their licence on serious grounds, there are a number of mandatory grounds, they have pursued every appeal and application open to them, and it's open to them to do so. I don't say it's not, it's really proper, but that they should be told that following the end of their appeal, that is it, and that there is finality at that stage. The policy objectives within these policies, and we may recall this from the substantive appeal, the overarching objective is for the Secretary of State to ensure that the scheme is operated effectively, robustly, fairly and lawfully, and within the terms of the policy. What the appellant tries to do is rely on one aspect of those policy objectives, which is the desire to avoid disruption to sponsored workers, and ignoring all of the other plainly relevant considerations that the Secretary of State has to balance that against, which include the maintenance of the integrity of the scheme, and the fact that where a licence is revoked, the consequences of that revocation should apply to all licence holders.
I suppose, strictly speaking, is this right, Mr. Magnall, that the strict view could be taken? Well, it's the end of the road. That's it.
Yes.
People have got. If that means that people have to leave the country, they have to leave the country straight away.
Yes.
But when one sees phrases like mitigating the impacts, that's in recognition, I assume, of the fact that human beings need a little time in order to rearrange their affairs. They can't literally be expected to leave straight away, and so a matter of days at least is contemplated. Is that right? Am I getting the right impression?
You are. That's absolutely right, my lord.
But I don't. I'm not getting the impression, at least from the Home Office perspective, that what's envisaged is, well, once all legal avenues have been exhausted, one now sort of takes stock and thinks, well, what can be done to try and regularise people's immigration position, whether that's 60 days or some other period. I mean, is that what do you say to Mr. Southey's submission that it would be reasonable, at least to give people 60 days to try and rearrange their affairs?
We say that what the policy envisages is that at the time of revocation, they will be given a period if they have. If they're coming to the end of the period anyway, the policy doesn't provide for an extension, but they know that that period is coming to an end.
Yes.
But if they have an additional period, then if that period is up to 60 days, that's the period they have.
Yes.
But what the policy doesn't say is that if your employer chooses to challenge this by way of judicial review, chooses to make applications, that period will stop running. And we've seen in this case that the majority of sponsored workers have stopped working for this employer. Now, I don't know, I can speculate as to whether that's a decision by the appellant to reduce its reliance, or whether it's decisions by those workers to seek to move to, because they have the opportunity to move their sponsorship to another employer.
Yeah.
But the policy does not, and deliberately I would suggest, does not encourage applications which will have the effect of extending that period. It so happens in this case that because of the periods of time it took for the JR that there was a very extensive period that relief was granted. But that's not because of policy considerations. Once the appeal was handed down on the 11th of March, it would have been open to the Secretary of State to say, well, that is it. that's the end of the road, as my Lord said. What the Secretary of State in fact said is that there will be a short period, recognising the considerations that my Lord has mentioned, which is 14 days. That has now become 30 days. So that is, we say that's perfectly rational in terms of the policy. So in terms of the agreement that the Secretary of State reached, there's no requirement on the Secretary of State to have agreed to that in the first place, and it certainly can't be said to be irrational to have said, well, it's 14 days. And I would say that the fact it's now 30 days, if the Secretary of State had said 30 days, I mean, if the court said, well, it shouldn't have been 14, it should have been 25, that's irrelevant because it's now 30. You would have to find that it would be irrational for the Secretary of State to give less than 30 days, because that's where we are.
Well, I think what's said now is that we're only 2 to 4 weeks away from a decision on the new application for a licence. And so it would be very harsh if in 2 weeks' time it's found that in fact there's a new licence. And so the employees shouldn't, it's not asking, I think the way it's put is, it's not asking for a great deal to say, well, let the employees have another 2 to 4 weeks so everyone will know where they stand.
So that brings me on to the other two grounds, which relate to this new application. Right. And my Lord will have seen, or may indeed recall, that when an application, when a licence is revoked, a sponsor has the opportunity to reapply after 12 months. So leaving aside legal proceedings, what will happen is their licence is revoked. They have what is called a cooling off period of 12 months. They then get to reapply. Prestwick did reapply. That's the subject of the third JR. That application was refused. Following that application, a 6-month cooling off period applies, and it's that second new application that forms the basis of these grounds. But the first point I made is there's no connection, no necessary connection between the determination of that licence and this interim relief that it relates to the revocation of the previous licence in 2023. It is right that if the previous application for a new licence had been successful, the one that's the subject of the third judicial review, fortuitously for the appellant, it would mean that it was seamless, that they would in fact never fall away from having some of the benefits of their licence because of the way that the timings worked. But there's no necessary link, and the fact that that application was not successful and they have now made a further application, that there is no link between that and the status of the previous application. We also say that on the merits of delay, and this is where I have to acknowledge the judge didn't deal with the merits of the point about delay in determining the application. It is set out in our summary grounds, and we say that the judge didn't need to deal with it in detail, but we also say that if he had done, he would have held it was not something that had a real prospect of success in terms. Firstly, because there's no policy requirement as to how long it will take. There's a statement on the website that says it's normally 8 weeks, but that's not a statement of policy. Secondly, the delay in this particular case was because of the appeal, and we say that's a perfectly rational thing for the Secretary of State to have done. And thirdly, in our grounds, we rely on the cases about delay, FH and MK and so on, where this court and the Court of Appeal, this court and the High Court have said that, and even in the context of individual applications for asylum and so on, where human rights are directly affected, that simple delay due to the administration not working as well as it should not found a claim for judicial review.
Unless it's irrational.
Unless it's irrational, yes. That's what FH says.
Yeah.
So in this case, we say there's nothing irrational. And in terms of the timing, the appeal was handed down on the 11th of March. I'm instructed that there were then canvassing of various dates when the inspection could take place, when both parties were available. The first of those was the 2nd of April, and that's when it took place. And the other point, my Lord, is that, my Lord says, well, it's only 2 to 4 weeks. It may be. That is the current estimate. as I understand it, 2 to 4 weeks. But of course, the application may be unsuccessful, in which case the appellant's position will be, well, we didn't know what the outcome of this was going to be, so we haven't taken steps to deal with this. The application for interim relief should be continued, which has been the hallmark of their approach. We say that at this point in time, their licence from 2023 has been revoked. The appeal has been conclusive. They have known about that for well over 2 years. Yep. They may or may not be successful with the new application for a licence. If they are unsuccessful, they would presumably seek to make a claim by judicial review. They may do so. But as of this point in time, we say that the judge was right to say that interim relief should not be granted in respect of this claim. So those are in effect our submissions. We say that this is a claim that has been brought. None of the 4 grounds are arguable. None of them have a strong prima facie case.
Well, I have to be careful because that's yet to be determined by the High Court.
Yes. It's yet to be determined, but my Lord can take a view as the Deputy Judge did. I mean, the claim on the policy, they accept it doesn't apply, and the idea that you can read into the policy something that's not there is, in my view, extremely difficult. To say that the agreement that was reached is irrational, we say is very difficult, and that only leaves the claim on delay. So we say that there is no strong prima facie case, and we say in terms of the balance of convenience, even if you're not with me on that the judge was right, because the judge refused it on both bases. We say even if you're not with me on the threshold for the real prospects of success, the balance of convenience here, there is a strong public interest in sponsors whose licences have been revoked for good reason not having those licences extended through the product of litigation for more extensive periods than is strictly necessary.
Is this right, Mr. Banksville, that analytically, if one is dealing with the balance of convenience issue,
yes,
you invite this court to do either of 2 things, I think. One is to uphold the judge on the basis that it was primarily a matter for him and that he hasn't done anything with which this court can properly interfere.
Yes.
Or, if he did fall into error in some way in conducting the balance of convenience exercise, that this court should do that again, but that it should again conclude that the balance falls in favour of refusing interim relief.
Yes. So I think strictly speaking, because my Lord's concerned with arguability, the first question is, was it wrong? Was it arguably wrong? But the second question is, in terms of whether the court should grant permission, which is technically the question before my Lord, you'd also need to consider, well, even if he was wrong, is in fact the outcome very clear?
Yes, that's an interesting, and that's very helpful, Mr. Macnell, and that's accurate, of course. But I'm just wondering, in practical terms, so if all I were to do is to grant permission to appeal, then it's just going to mean yet further delay.
Yes.
Is that in everyone's interest?
It's not, my Lord, because if you were to simply grant permission, if you were to take a very narrow approach and say, well, this is perhaps barely arguable, I'm going to grant permission, but you were also to extend interim relief pending, presumably, the hearing of a full appeal, in effect, it would give the result that the appellants sought. As I say, they have had 30 days since the appeal.
Well, that's why I raised the question. I mean, this is not unusual that a court finds itself in the situation where the threshold stage is equivalent to the final stage.
Indeed.
I'm just wondering, am I able to deal with the appeal, or does that require more than one member of the court to sit?
I was hoping my Lord would know the answer to that. I had always thought it did require 2, but I don't know the basis.
I think it would. Yeah. I've never sat on an appeal as a single member.
It would, in my submission, be open to my Lord to sit as a judge of the High Court if you were minded to grant permission and remit it back to the High Court. and then to simply decide it.
I'm not sure I can do that. I can grant permission or refuse permission, but if I grant permission, I can't deal with the appeal, I think.
I mean, it does seem, with respect, it seems an unnecessarily cumbersome procedure if the answer to this is that my lord is faced with do I grant permission, and then Southey and I come back in whatever time in the future,
Exactly.
where there are two or more judges, and have this argument again at a point where it may well be academic.
Well, right, exactly. That's what's concerning me. But that's certainly helpful. Is there anything else that you would like to say?
No, I think just on that point, I think that is a point that my lord can take into account in determining the question. So in determining whether permission should be granted, bearing in mind that the public interest is a factor, that my lord can take that into account.
Speaking for myself, that appears to be right, because that's certainly the approach courts take. For example, when we have applications to stop a strike or something like that, we often take into account that, in effect, the final relief being sought is going to be granted or refused, depending on what's said at the interim stage.
Yes.
Right.
I don't think there's. Yes. I don't think there's anything else.
Thank you very much.
Thank
Yes,
you.
Mr. Southey, do you want to reply?
Yes, my lord. Can I just a few things? Firstly, just a minor in one sense factual matter. My learned friend referred to the fact that there has been through one process or another a effectively stay on the enforcement action being taken against the employees for about 2 years. It's important to recognise that there was, of course, a period where permission had been refused to appeal to the Court of Appeal, and no application indeed had been made to reopen that because there weren't grounds to reopen that. During that period, no action was taken in relation to revocation. Unclear why that's the case. But it's important to recognise that it's not. This isn't a situation where the Secretary of State has been sort of trying to take immediate action at all stages. The Secretary of State has recognised that there may need to be, would appear to have recognised there may need to be delay in enforcement, effectively unrelated to litigation. And secondly, my lord, learned friend says the policy is not about giving 60 days. Submissions he made about the policy. 2 points I'd wish to make about that. Firstly, the point I was trying to make is that why, in one sense, have 60 days been said? It's clearly because it is intended to allow for people, companies, to reorganise their affairs in an appropriate manner. And my lord will remember from the first appeal, there was evidence, for example, about the extent to which employees can make applications for employment with other employers with sponsor licences. So that's presumably why the 60 days is there. It's to enable people to reorganise their affairs
And remind me, is the position that they can apply to others? Yeah.
Yes. And there was evidence about how many jobs. There was some dispute about how realistic that was, but yes, it is. Yeah. But the second point is, my lord, my lord was pressing me about how long. Can I just make clear one thing, thinking about it, particularly given my learned friend's submissions about 60 days? Of course, the way the grounds are phrased would be that it would be open to the court to conclude on the substantive judicial review that time, in fact, should only have been extended until the determination of the sponsor licence application. That's how the ground. That's one of the express points. So I was put in one sense, what was my high point, because we were relying on 60 days. But it's still the case that it would be open to the court to say, well, you're not entitled to 60 days, but you are entitled to wait because of the harsh consequences until the determination of the sponsor licence. And at the risk of repeating myself, there is a rationality issue in relation to that, a particularly strong one, we would say, because what is the point of causing all this disruption if in 2 to 4 weeks' time, the situation may well be that the company can resume employment of overseas workers. My Lord, then going on to the issue of R, my point about R, the fundamental point about that is that what that recognises is that within the concept of whether or not a decision is wrong is flexibility. And it must be, in my submission, appropriate for the court to take account of the fact that this isn't what the court perhaps often has, an order made after fully argued oral hearing where all the parties have been able to present their cases. This was a case made, understandably, I'm not being critical of the judge when I say this, but it was made very rapidly, without apparent consideration of the reply, and it was made without the benefit of oral argument. And we cited West, for example, as an example of why oral argument is potentially important. And that has to be, in our submission, a relevant factor. This isn't the same situation as somebody who's appealing against an interim order made after full argument. Now, my Lord, there were a number of arguments about the rationality, and my learned friend in my submission was striking in the sense that his submissions essentially focused on the need for finality. The appeal had come to an end, it needed to bring things to an end. Now, my learned friend accepted that the evidence was there might need to be actions taken to mitigate the effect of a revocation. It's important to recognise the way that evidence was expressed, as is clear from the claimant's grounds, was it wasn't actually primarily focused on employees rearranging their affairs. That's what the 60 days we would submit is about, because that's not simply restricted to the care sector, that 60 days. What the evidence specifically talked about was the need to mitigate the impact on continuity of care. And that's a critical point here when looking at rationality. My learned friend's arguments, as I say, suggest, which is consistent with the papers, all the Secretary of State has looked at is the history of this matter. What actually one should be looking at in terms of if you're going to reach a rational decision, is the fact that you've got vulnerable people in care. The evidence is there may be disruption to their care if staff are lost. You're looking at a potentially very short period of time until the decision is taken on the licence application. And that's where the rationality issue is perhaps at its strongest, we would say, because on the face of it, there's no consideration of whether or not you should allow a short period to avoid that disruption in circumstances where there may be a resolution of this problem in the very near future. And that's the critical point in terms of rationality. And that's what was striking in one sense about my learned friend submissions. They were all focused on, look at the history of this matter. We must be in a position to say enough's enough. Well, that is, I'm not saying that's not a relevant factor, but equally relevant is the fact that at its lowest, we're asking for a very short period to enable the application to be determined, the application that's been now outstanding for 6 months, and we're asking for that to enable continuity of care. And that's what the policy is, the witness statement, I will remember from the Court of Appeal, made clear. There can be mitigation to ensure continuity of care. The Secretary of State accepts, in terms of how enforcement action is taken, continuity of care is a relevant factor, but on the face of it, it doesn't appear to be considered. Then in terms of delay, my learned friend says there's no connection, essentially, between that issue and interim relief. Firstly, in our submission, there is a relationship between the reasonableness arguments in terms of extending time and the delay issue, because the fact that it's taken 6 months in circumstances where the policies suggest it could have taken far less. In our submission, it is relevant when considering whether to extend time. The fact there may be a resolution. But secondly, there simply wouldn't be a problem if this had been determined promptly. Now, my learned friend relies on the appeal and says, well, that justifies the failure to process this application. That is ex post facto reasoning, as I've already indicated. There was nothing said to the company during the relevant time that the appeal was being relied upon. Inspections were being arranged. And it's difficult to see why that would justify the delay in circumstances where the inspection may have resolved this, may have made had the inspection taken place in December, which was when it was originally scheduled, may have made the whole appeal unnecessary, which would have saved both parties time. My learned friend says, in terms of the delay also, be very cautious because, of course, you can't be certain that the sponsor licence will be granted. It may be unsuccessful, and then interim relief will be sought at that stage, further interim relief. Well, that's speculative. I don't know at this stage whether it's going to be granted or refused. It may be granted. It's speculative also that we will, as officers of the court, be of the opinion that there is an arguable case for interim relief. It's speculative that the judge will grant interim relief. If we get to the point where interim relief is granted following a fresh decision, that's presumably because the judge is of the opinion that the test for a grant of interim relief is met. That can't be, the possibility that an application will be made for interim relief in our submission can't be a reason for effectively refusing to extend the leave for the short period to enable the application for a sponsor licence to be determined. Finally, in terms of balance of convenience, in our submission, there are grounds for intervening with the judge. I've already addressed them. The primary one, though, is again the failure to recognise that what's an issue. One of the key issues is that what may actually be a relatively short period of time, which is the time until the determination of the application. And if one focuses on that time, in our submission, the balance of convenience is clear, which is that what an injunction will do is stop substantive disruption until a process that is due for, we would say, should already have been resolved, but in any event is due for resolution very soon. It prevents substantive disruption until that process is concluded. And also until, I should say, the decision on the papers. The one final thing, actually, I've somehow missed in my notes, but I intended to make. My lord asked the question of what's the relevance of the fact there's been no decision on permission. My learned friend says, well, there's been no decision on permission, that's true, but you can take account of the fact that the judge was unimpressed with the merits. But of course, the judge didn't address, as my learned friend fairly accepts, the merits of the issues in relation to delay. So there is, we would say, an unresolved issue on permission that we would obviously argue has merit, but certainly still to be resolved. Well, I think that covers everything.
Thank you both very much. I will not give judgment straight away, but I hope to be in a position to come back into court and give judgment at not before 3 p.m.
Thank you very much.
Court, bye.